The next topic is Doctrine of State Responsibility. In this doctrine, it implies that a state may be held responsible for an internationally wrongful acts, either directly or indirectly, and such act is imputable or attributable to the state which causes injury to the national of another state. In this doctrine, it implies and provides that every internationally wrongful act of an state entails the international responsibility of that state. Elements of state responsibility. First, there must be an act or omission which is in violation of international law. Second, such act or omission is attributable to the state. Third, such act or omission causes damage to a third state, either directly or indirectly. The elements of an internationally wrongful act. First, the act or omission is attributable. So, the first element is that the act must be attributable to the state under international law. Second, the act or omission constitute a breach of an international obligation of the state. Acts attributable to the state. First, acts of the state organs. This refers to the acts of state organs in their capacity provided by law or under instruction of superiors. Second, acts of other persons. These refer to the group of persons exercising elements of the governmental authority in the absence or default of the official authorities and circumstances such as to call for the exercise of those elements of authority. Lastly, third, acts of revolutionaries. This refers to the conduct of an insurrectional movement which becomes the new government of a state or part of a state. There are two kinds of state responsibility. First, direct state responsibility, which refers to the superior government officials like chief of state or national legislator. Second, indirect state responsibility, which refers to the inferior government officials or private individuals. In this indirect state responsibility, the state will be held liable only if, by reason of its indifference in preventing or punishing it, it can be considered to have connived in effecting its commission. In order for this doctrine to be enforced, there are three requisites to be complied. First, the nationality of the claimant. Second, the foreign alien must exhaust all local remedies in which Calvo clause will apply. Calvo clause means to a stipulation which states that the foreign party must rely exclusively on local remedies and not seeking any diplomatic representation. Third, he must be represented in the international claim for damages by his own state. These are the following defenses that a state can invoke in order to be free from liability. First, if there is a consent, a valid consent by the state to the commission of a given act by another state. Second, if the act constitutes a lawful measure of self-defense taken in conformity with the Charter of the United Nations. Third, if the act constitutes a countermeasure taken against the latter state in accordance with the Articles of State Responsibility. Fourth, force majeure. If the act is due to occurrence of an irresistible force or unforeseen event, or it's beyond the control of the state. Fifth, if the author of the act in question has no other way in saving in a situation of distress. The last one, necessity, if it is the only way for the state to safeguard an essential interest against a grave and imminent peril. The following are reliefs available where a state is liable for an internationally wrongful act. First, declaratory relief. A declaration by a court that as to the legality of an act constitutes a measure of satisfaction or reparation in the broad sense. Second, satisfaction. It involves a measure other than restitution or compensation which an offending state is bound to take, an apology, or other acknowledgement of wrongdoing, or punishment of individuals concerned. Third, restitution. It involves wiping out all the consequences of the breach and reestablishing the situation which would probably have existed had the act not been committed. Fourth, compensation. It involves payment of money as a valuation of the wrong done. The next topic is refugees. For the benefit of the doubt, refugees and internally displaced persons are different to each other. They are two different terms because refugees are people who, owing to well-founded fear of being persecuted for reason of race, religion, nationality, membership of a particular social group, or political opinion, are outside the country of his nationality. And being outside of their former habitual residence as a result of such events, they are unwilling to return to it. While internally displaced persons are those who have been forced to flee their homes suddenly or unexpectedly as a result of armed conflict, internal strife, systematic violation of human rights, or natural or man-made disaster, and who are within the territory of their country. The following are the elements before one may be considered as a refugee. First, the person is outside the country of his nationality or outside the country of habitual residence. Second, the person lacks national protection. Third, the person fears persecution in his own country due to race, religion, nationality, membership of a particular social group, or political opinion. Although they are refugee, they still have rights that are guaranteed to them. First, they are uh, they have the right not to be discriminated. Second, they have the right to have administrative assistance. Third, they have a right of freedom of movement. And fourth, they have a right to be issued travel documents. And lastly, they have the right not to be penalized for illegal entry of certain country. And when we speak of refugees, definitely the principle of non-refoulement shall be invoked because in this principle it provides that a state may not deport or expel refugees to the frontiers of territories where their life or freedom would be put in danger or at risk. And the next topic is treatment of aliens. As a general rule, stated in the Articles of State Responsibility, no state is under any obligation to admit aliens. However, a state can determine in what cases and under what condition it may admit such aliens. And once it admits aliens under international standard of justice, aliens should be protected by certain minimum standards of humane protections. And once the alien is admitted by the state, the liability of the admitted alien will attach to that certain state. And when we talk about treatment of aliens, it always involves the term diplomatic protection. What is diplomatic protection? Diplomatic protection refers to the invocation by a state through a diplomatic action or other means of peaceful settlement of the responsibility of another state for an injury caused by an internationally wrongful act of the state to a natural or legal person that is a national of the former state with a view to the implementation of such responsibility. Also, it involves the term extradition. Extradition refers to the right of a foreign power created by treaty to demand the surrender of one accused or convicted of a crime within its territorial jurisdiction, and the correlative duty of the other state to surrender him to the demanding state. And when we talk about extradition, there are certain things to be considered. First, there must be an extradition treaty enforced between the requesting state and the requested state. In absence of the treaty, the requested state has every right to grant asylum to the fugitive. What is asylum? Asylum is a protection granted by a nation to someone who has left their native country as a political refugee. Second to be considered is the crimes for which the person to be extradited is charged are extraditable within the terms of the treaty. So the principle of specialty comes. So principle of specialty means uh, a fugitive is extradited may be tried only for the crime specified in the request for extradition and included in the list of offenses in the extradition treaty, unless the requesting state does not object to the trial of such person for the unlisted offense. Third to be considered is that the act for which extradition is sought must be punishable in both the requesting and requested state. So the rule of double criminality applies. So what is double criminality? Double criminality rule refers to the act for which the extradition is sought must be punishable in both the requesting and requested state. So the fourth thing to be considered is that any person may be extradited, whether he is a national of the requesting state or of the state of refugee or of another state. So it it means that he need not be a citizen of the requesting state. Lastly, to be considered is that the offense must have been committed within the territory of the requesting state or against its interest. In extradition, it must be complied with procedural due process. So these are the following procedures to be complied. First, a request for extradition is presented through diplomatic channels to the state of refugee with the necessary papers for identification. Second, the request is received by the state of refugee. Third, a judicial investigation is conducted by the state of refugee to ascertain if the crime is covered by the extradition treaty and there is a prima facie case against the fugitive according to its own laws. Fourth, if there is a prima facie case, a warrant of surrender will be drawn and the fugitive will be delivered to the state of origin. For further information, extradition proceeding is sui generis, so it means it is not a criminal proceeding which will call into operation all the rights of an accused as guaranteed by the Bill of Rights. For further information, deportation and extradition is of different meaning because in extradition, it is effected at the request of another state, while in deportation, it is a unilateral act of the state. And in extradition, it is based on offenses committed in the state of origin, while in deportation, it is based on causes arising in the local state. Lastly, in extradition, it refers to calls for the return of the fugitive to the requesting state, while in deportation, it refers to the undesirable deportation. It refers to the deportation of undesirable alien to the state other than his own or his state of origin.